The DA is briefing the media ahead of tomorrow's High Court challenge against the Employment Equity Act. The party argues the legislation's race-based employment quotas could exclude countless South Africans from job opportunities. We cross live now to that briefing.
It's not a recent thing that has emerged, for example, out of the draconian new quotas you've seen published on social media and in the newspapers. This comes a long way from the 6th Parliament, when the then Employment Equity Amendment Bill was passed, and we opposed it from the beginning for the key reason, as Willie has explained, that it will continue to drive unemployment up, economic growth down, and make far more people unemployed and marginalized in our economy than they already are. One thing I've learned in all my years in politics is that you never judge a bill by the intention of the government. You judge the act that follows by the impact it has in the real world. And that is the critical measure. And we're not flying blind here. We've had an employment equity regime which was meant to drive employment equity for the last 25 years. And we've seen since 2008 unemployment almost double, from 5.5 million on the expanded definition to 11.1 million last year. And that is primarily as a result of failed government policies that drive away investment and discourage growth. That wasn't their intention, I'm sure, but it is the effect. And we've done many surveys of potential investors who decide not to invest or who disinvest from South Africa, and they name electricity uncertainty and race laws as the primary factor that drive away investment. So we must judge things in the real world by the impact it has on more and more people driven into extreme poverty, and millions of children literally are feeling the effects of that through stunting and malnutrition. That's the impact. And so are you going to continue tightening a regime that has already had that impact, or are you going to look for another strategy to empower and include marginalized people who need to get into an inclusive economy? The DA is absolutely committed to achieving that. We want employment to reach levels of highly developed, functioning, booming economies, and we can do that with the right policy regime. And that would be real inclusion, real redress, real transformation. But continuing a failed system and taking precisely the elements that made it fail and make them worse is in fact doing precisely the opposite of transformation, redress, and inclusion. And that is our main problem with this act. Now, we all know that Section 9 of the Constitution is the Equality Clause. Section 9.2 is the Redress Clause. Section 9, which is the Equality Clause, forbids discrimination on a whole host of grounds. Section 9.2 says there is such a thing as fair discrimination to redress the legacy of the past. But that is not a blunt instrument. Any discrimination that is deemed to be fair has to be proved to be fair. You can't just do anything in the name of redress and claim it is fair discrimination. There's a benchmark that has to be reached to qualify as fair discrimination under Section 9.2. And this Act fails that benchmark test 100%, we believe. And that is the primary constitutional argument that we will be making in court. We have a technical argument as well, which is that this act should have been tagged under Section 76 of the Constitution because it has such a profound impact on many of the provinces. Now, as you will all know, when a bill that is before Parliament is going to impact provinces, it has to go through the process defined in Section 76 of the Constitution. And that is a different process from a bill that doesn't particularly impact the provinces, which then goes through a Section 75 process. A 76 process is different from a Section 75 process, and one of the primary differences is that it gives a much bigger role to the National Council of Provinces because they represent the provinces. And if the NCOP turns it down, you need a 2/3 majority in Parliament to pass that. So it's a fundamental different process. And we are arguing that it should have been done under Section 76. But that's the technical argument. We also have a substantive and principal argument that I set out to you at the beginning. Now, we had a previous employment equity regime that was passed, I think it was 26 or 27 years ago. And that one allowed companies to set targets to achieve more equity in their workplaces for designated groups, which are people of color, women, and people with disabilities. And they enabled companies themselves to look at their context, to look at the number of people qualified in the specific fields that they might need, to look at their geographical situation, to look at a whole range of factors that impact on your business, and then to set targets, and then to seek to achieve those targets. There were penalties for not achieving the targets, but one of the fundamental ways in which this new Amendment Act goes far further is that it puts extreme penalties on companies for not achieving quotas set by the minister. And that is a fundamental difference. In the previous regime, companies looked at a whole range of factors affecting their businesses, and they could then set targets that they felt were fair, stretch targets often, that they felt were fair and that they could reach, and they were judged according to those. In this new regime, the minister, under Section 15 of the Act, gets to be able to set draconian national targets for every sector of the economy. Sectoral targets, they call it. It's a blunt one-size-fits-all regime for the entire sector, and that can be national. And every employer in that sector will have to meet them. And if they do not, a labour inspector can go out. The Director General of Labour can put a huge fine on that company amounting to 10% of turnover, not 10% of profit, 10% of turnover as a penalty. Now that ceases to be a target. When you have an imposed target set by the national minister that doesn't take any account of the context in which your firm operates and makes a sectoral target binding on every single employer in that sector, and then imposes a severe penalty for failure to reach it, that is no longer a target. That is a quota. And our courts have previously and repeatedly found that quotas are unconstitutional. There were some famous cases in the police force, for example, where an Indian person was denied promotion at one of the top ranks of the SAP because they said they had already appointed one Indian person and their quota in the population as a whole did not allow them to appoint another Indian person because they formed too small a proportion of the national population. And that was taken to court, and the court ruled that that was unconstitutional because it set an absolute barrier against a person on the basis of criteria that they had no control over, the circumstances of their birth. And so, while we strongly support in the Democratic Alliance redress measures, they need to be fair, they need to be rational, they need to promote economic growth, and they need to get people into jobs. That is the number one objective. We have a youth unemployment rate of 42%. That is horrific. It's the highest recorded unemployment rate in the world. And the most important form of redress is to get people into jobs. The more you get people into jobs, the more they're included in the economy, the more they have dignity, the more inequality comes down, the Gini coefficient reduces. Getting a job is the best way to fight crime. It is the best way to give people dignity and a future. And the best way to get a job is to have a government that creates policies that encourage investment and that don't punish investors and set all kinds of barriers to investment. Because people with good ideas and capital and skills can invest anywhere in the world. Everyone wants them. Our government often departs from the point of departure that says in its own head, people have to invest, business have to invest in South Africa, so they might as well invest on our terms. It doesn't work like that. If government sets policy that creates terms that are unacceptable and that are impossible to meet without fear of tremendous penalties and big fines and the risk of criminalization through a charge to the labor court, who's going to take that chance? People are going to close down their businesses and certainly are not going to invest here. And so this is the very opposite of redress and the very opposite of transformation. And that is something that we need to understand. We can't keep on pushing a failed experiment and tightening the screws tighter and tighter and believe things will improve. The unraveling of our economy is the only thing that is going to accelerate, and jobless numbers are going to grow and grow. And so the DA's approach to this is policies that encourage investment, that drastically improve education. And as more and more jobs come onto the scene, more and more people get into jobs, there are also more and more senior jobs as companies invest. And that is the best form of transformation because there's a growing pool of jobs and a shrinking pool of minorities, actually. So the best way to empower majorities is to grow the economy. It's as simple as that. Instead, we have policies that shrink the economy, which means you get an already empowered elite fighting with each other over a shrinking number of jobs. And it's an insane system. We also believe it's unconstitutional because it's manifestly unfair. And when you discriminate to achieve redress, which we support in specific circumstances, we do not believe that this act meets that benchmark. It is specifically going to discriminate against particular categories of people. One thinks of Indians in KwaZulu-Natal and coloured people in the Western Cape, for example. It's just a consequence of our history that there's a very large concentration of Indian people in KwaZulu-Natal and a very significant number of coloured people in the Western Cape. But if you apply national targets to the Indian population, I don't know exactly what percentage the Indian population makes up of South Africa, but I don't think it could be more than 3%. So if a national target is imposed on firms in KwaZulu-Natal, how many Indian people are going to have to lose their jobs to meet the targets and the quotas? It's going to mean that not only will people not be able to get jobs because firms will close down, it will mean that people in jobs will have to be let go because the firm is going to face severe penalties and the risk of criminalization for not meeting what is in fact a quota. Now, those are totalitarian powers. They don't belong in a democracy. And they certainly don't belong in a country where we desperately need jobs above everything else. So the DA's commitment is to see the millions of young people who have a future that can only be described as hopeless, to give them hope by ensuring we grow this economy and get people into jobs and improve education and ensure that people have the skills they need to compete for the jobs that are there. And that we don't have a country that continues to define everybody according to their race and their other biological attributes that they have no control over, and make sure that everyone understands that their ability, their opportunity, and their work ethic is what is going to get them to the top, not their race and not their political connections. Our Constitution promises us the goal of a non-racial, democratic and just society. And when we see measures that are taking us in the opposite direction, the DA has to call halt. Of course, the ANC is going to say things to us, for example, like, you are anti-transformation. In fact, every one of the DA's policies drives the real transformation, which will happen through economic growth and more jobs for more and more people. That is real transformation. The only people who are significantly anti-transformation is people who take failed policies that have doubled the unemployment rate since 2008 and turn the screws tighter on those failed policies. And that is why we are going to court. We are committed to a non-racial, inclusive, democratic South Africa. All of us have worked as hard as we can to achieve that. Our support is growing because of that, and we're not going to stop now. Thank you very much.
Thank you very much, Helen. It's now a privilege for me to introduce Mr. Michael Bram, who is the spokesperson on employment and labour and is also a member of parliament. Michael has been a labour lawyer for more than 40 years now, and he has been involved in this process when the previous parliament, the sixth parliament, deliberated and voted on this Amendment Act. Well, it's not a bill anymore, it's an act now. So it's a privilege for me, and thereafter I will introduce Nashley Sharif, who is a MPL here in Gauteng, who will then handle questions, but I will do that afterwards. Thank you very much, Michael.
Thank you, and thanks very much for coming. The bottom line is that the minister has to show that she can discharge the onus of proof that the engineering that she's entered into does not break the legislation, and that it is fair discrimination. Now, the word fair in the discrimination is absolutely vital. All of us have come from a dark past where we had the National Party who entered into discrimination, and that discrimination was social engineering of its highest form. We've seen this throughout history where social engineering has been a major nightmare. We saw it with the Nazis, we've seen it across Europe, and we saw it, in fact, in this country for many years under the National Party. We can't have that again. We don't want to have a race register again. I don't know if you've all seen, but they've now put out a form where you have to fill in, each employee has to fill in a form to say whether they are white, black, Indian, coloured, male, female, disabled, etc. Now that is harking back to the past, and our court case is about that very onus. That's what it boils down to. It's a simple concept. The minister has to show that these targets are there specifically because it's going to create some sort of redress. Now, as Helen has explained, quite simply, we've had 26 years of exactly the same legislation, and we are expecting a different result. Now, every year, all of us watch, and I'm sure all of you have been watching the employment figures. Every year it goes down, and every year we have a problem, and we all scream and shout and say, why are we so bad? Why are we the worst employment in the world? And the worst employment in the world, because COSATU tells us we're at 42% now in the expanded definition. In fact, Helen, COSATU is telling us that the youth are almost at 70% unemployment. Now, if that's the case, there's got to be something wrong. We can't, and as Helen puts it, you can't tighten the screws on the legislation. I'll put it slightly differently. You can't take that same experiment, like Einstein said, and have a result and then keep doing it for 26 years and expect a different result. That's a sign of madness. And we need to actually then go to the courts, which we're going to be doing tomorrow, and we'll argue this out, that the minister has not in any way effectively looked at discharging that onus of fairness. Because that's what our constitution is. It's got a golden thread that runs through that constitution. And that golden thread is one of fairness. And we're not here to have a race register. We're not here to have people judged on what the color of their skin is. Now, there's argument. There is, yes, solid argument saying that you're still reflecting the majority of the upper echelons of the employment are white, pale and male. And yes, that is absolutely correct. But the legislation has made it worse. So what we're looking at is redress. Now, the Democratic Alliance is a party of the Constitution. We completely adhere to the law. We completely adhere to the Constitution, and we're not going to breach the law or the Constitution, whether you agree with it, whether you agree with the law or not. We're not going to breach that law. We do agree with the Constitution. And here we have a chance. We need to use the tools that the Constitution allows us to go to the courts and to say that a piece of legislation is wrong. It's unconstitutional. And why is it unconstitutional? And I hark back to it again. It's because it's unfair. And it's unfair to everyone, because if you're doing that, the business community are going to tell us, quite simply, that they're going to stop growing. We've already seen with the large business community jobless growth. You've all seen that, where people are making more money, but they're not creating any jobs. So the world is telling us that who creates the jobs in the world today, and in particular in South Africa? It's the small business community. And the small business community, I can tell you right now, are in the situation now where they're standing and looking at this and saying, well, we're over 50 people, because the legislation recognizes that under 50 people you don't have to adhere to this legislation. We're over 50 people, let's shrink. Let's shrink to under 50, or let's invest elsewhere. Let's mechanize, let's computerize. Let's do everything we can to not employ anyone. Now, anecdotally, I practice in the field of labor law, and I'm in the CCMA and the Labor Court weekly. Anecdotally, I'm telling you now that the small business community are very excited, of course, because those under 50 employees saying, well, no, we mustn't grow to 51, God forbid, because we're going to have to face this unfair situation. Those that are under 50 are planning to do whatever they do and to employ whoever they need to employ. I haven't met one business person who says, I'm not going to employ that person because they happen to be colored, or they happen to be black, or disabled. What they're doing is they're employing people that are productive. And we've got to understand that. That's what business is all about. They employ people that are productive and can grow their business and grow the economy in due course. That's what this is all about. And we're all in SHIP South Africa together. SHIP South Africa has developed a leak. That leak has created massive unemployment, and in fact deemed to be the worst in the world. We're also deemed to be the most unproductive. The bottom line is we need to look at it and say, how can we actually turn SHIP South Africa around? How can we do it? Now, the Western Cape has followed this experiment now for over 6 years, and they've brought the unemployment down to just below 19%.
Coming back to you now from that DA press briefing ahead of their High Court appearance tomorrow.